Every Tuesday, we do bring in immigration updates, and we're going to take live questions from 5 p.m. Central Time to 6 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Yeah, we had some breaking news over the weekend. Normally, during previous Trump administrations, we kind of had a running joke that they always announced things on Friday afternoons so that the media wouldn't catch on to it. And now they've moved on to Saturday afternoons. Saturday, the Department of State posted an update on their website saying that they're no longer going to allow people to apply for the visa in a country other than their country of citizenship or country of residence. That means no more third country national stamping. So if you are in the US and used to going to maybe Canada or Mexico to get your visa renewed, that's not going to be an option anymore. You'll have to only apply in your home country. We also want to just talk about the visa law tsunami, how to protect your future. There is just so much going around. It's like a whirlwind. Every day something is changing. How do you keep track of it all and make sure that you are protected so that you can remain in the US and continue your lawful stay? And then a common question that we get, we deal with documented immigrants, high skilled immigrants that do everything they can to make sure they're maintaining their status and have all the right documentation. So, how is it that undocumented workers are able to find work in the US and get paid in the US? And should legal immigrants be concerned about that? How does the fact that there are people doing this impact you if you're here on a visa? What you should be concerned about with that?
First thing, let's discuss about this topic of the visa stamping, Emily. It's going to be negatively affecting Indians much more than any other country nationals. The main reason is that Indian consulates are backlogged in the visa appointment significantly, especially in some particular categories, almost 2 years of waiting period to get it. And they were trying to go to Thailand, Vietnam, or some other country and getting the visa stamping. Now that's been chapters been closed. Now we have a lot of people who are wanting to visit their home country, and especially India, and they were going to Mexico or Canada because it's easier to get an appointment there because U.S. consulates in Canada or Mexico used to allow third country nationals. And in fact, Biden administration has issued a memorandum previously that anybody can go to any country and apply for the non-immigrant visa stamping. So that's completely reversed. So this is going to impact Indian nationals very significantly if you want to get the visa stamping though. So please, if you want to make any arrangements for the travel, you need to have an advanced planning. Otherwise, it's going to be troublesome, especially if you have something emergency and that you're going to India and you don't have a visa stamping, you may be stuck there for almost 1 year if you don't have a proper visa appointment in advance. The reason is that um, the appointments are backlogged there and we don't have the drop box there, and now you cannot go to the third country to come back into the country. And if your job does not exist by the time you come back, you have to withdraw your visa application, because if your job does not is not there, you cannot apply for H-1B or L-1 visa because your job does not exist anymore. So that's going to be a very major problem. And we were discussing a couple of years ago that the Biden administration at that point of time was initiating, bring the jobs back to United States, where all these consulate jobs are outside the country. We can bring them back and use those consulate jobs here by visa stamping. But of course, Trump administration doesn't want to bring the jobs to United States and want to export to other countries by having the consulate jobs there rather than having the visa stamping here in United States. He hasn't commented anything about that, MD.
Yeah, so we've already at the beginning of the year had a restriction on Dropbox to where at one point anyone who was doing a renewal within 4 years could qualify, and then it got shrunk to 1 year. And then just starting September 2nd, we eliminated Dropbox altogether for all types of work visas, which increases the number of people that need to book an appointment. On top of that, we eliminate the interview waiver for senior citizens and for kids. So now we have to use up resources on those appointments. And now people that were able to go elsewhere in the world have to go only to India. It just spells a disaster looming for people who actually need to travel on an emergency situation. if you're already seeing that you're having a hard time getting an appointment when you need one, it is going to just keep getting worse over the next 4 years with this change. All
Coming
right,
to the
on to the
car.
next topic.
Sure.
There's just so much going on, such a whirlwind of changes in immigration. How do people keep up with that? What can they do? What should they do in order to make sure they're protected going forward?
One thing I want advise all the people is try to get the decision before your I-94 expires. Let's say your H-1B is expiring in December of 2025 and you're applying for an extension. You know, according to the rules, if you file an extension, you can continue working for a period of 240 days after December of 2025. You already know that, but don't use that one. Get the decision before December of 2025 by filing a premium processing. The reason is that if you get the denial by any chance, though, if you get the denial after December, then you will have to leave the country and then probably go outside the country and get the stamping, which Emily has described how long it's going to take for you under the current circumstances. Uh, at the same time, by any chance, if the denial comes before December, you have a chance to refile the entire application again, even though you got the denial. So it gives, that is the number one thing that I recommend all the people. Also, whenever you enter into the country, please check the I-94 to make sure that I-94 is reflecting properly. Don't come back to us saying that my I-94 expired in February of 2025 and you are coming to us in September of 2025. That is a very dangerous thing. We want you to check your I-94 before you do it. And definitely, we want you to follow our channel. We have been established law from past 30 years, and we've been doing Reddy Neumann has been existing for more than 20 years, 28 years, I'm sorry. And we do bring in immigration updates very frequently. Every week we take live questions. We do have a daily conference call where approximately 40 to 50 people attend. One of the time, you should just every 1 month, we recommend that you come to the Zoom calls. It's free and you can hear what the other people are telling. It's just the knowledge, not what you gain by yourself. You should also listen to what the other people are asking the questions so you can get a creative idea of what's going on around you. If you are a non-immigrant status, if you are on a H-1B, H-4, L-1, L-2, or any F-1 visa, though, OPT STEM extension, I recommend strongly at least once in a month, attend the free Zoom call, which we have given the Zoom link there, and you can ask questions there. We have more interactive session there. Every day we're conducting from past 13 years, every single day. We do it for free. You can come there and ask questions. And please do come in immigration updates every Tuesday. Please spend with us 20 to 30 minutes every Tuesday. And we do have and if there is any emergency things, if there is any things that get updated, we do update. So please subscribe to our channel so that if there is any news update, you can get it. Please subscribe to our newsletter at RN Law Group. We do publish articles and we do only address business immigration, employment immigration. We don't address not other immigration. There are many other immigrations, which I would explain to you later on, though. But we do only address employment-based immigration, to an extent, family-based immigration. But we don't address asylum. We don't address deportation, certain other things. So please come and subscribe to our channel so that you can get the update. Anything more from you, Emily?
Yeah. Yeah. One thing we learned during the previous Trump administration is there is always a lack of transparency when it comes to changes. So you might know right now that they have been making announcements in advance of things. We see policy memos getting updated. We see the State Department actually announcing things. Of course, the announcement over the weekend took effect immediately. So there was no advance warning for anyone. The change in Dropbox that happened at the beginning of the year had absolutely no announcement whatsoever. And so, um, we a lot of times saw when we are filing extension applications or transfer applications with the Immigration Service, we generally know what to expect. We file these all the time. We know what the issues are. We know what types of RFEs might be there. We have a pretty good sense of when a case is going to be approved or when there might be an issue. But then they just start changing things without an announcement, changing how they interpret things, changing how the trends are in adjudication, and you don't find out about it until you get an RFE that raises a completely new issue that's never been an issue before. And when those kind of things happen, it's kind of happening after the fact. You can't go back and change what you've already filed. And that those types of changes are what led to unexpected denials and sudden status loss during the previous Trump administration, which is why, to reiterate, it is so important to file early, file in premium processing, get the decision before your current status expires. Because in case you get one of these unexpected weird RFEs and aren't able to successfully respond to it, you have so many more options. You can refile, you can file a change of status, versus after your I-94 is expired, you're very limited in your options there. And you can also consider, what we found a lot of times during the previous Trump administration is while people had one application pending, they kind of filed a backup application from time to time. We saw a number of transfers where people would file an extension with their regular company and then file a transfer as a backup plan. I don't know, depending on the company that they're doing that with, maybe a good idea or not, but you could consider filing a backup change of status to B2, a backup change of status to H4 or L2, so that you have something pending and on the books by the time your I-94 expires, in case you're not going to be able to get the decision on whatever you filed before your I-94 expires. So moving on to the last topic, our clients jump through so many hoops, go through so many hassles in order to get the visa, in order to get here legally, get the I-94, make sure that they're following all the rules. How is it that undocumented immigrants are able to find employers and work in the US when there's so many hurdles that legal immigrants have to go through?
I know, MD, I've been in immigration business for past 30 years. Of course, you've been in this business for more than 20 plus years right now. There are, this is how some of the people who are not documentarily staying in this country get an employment, work, and get a paycheck from proper companies, though. What they do is that they get fake green cards, they get fake driving license, they get fake social security numbers that are available in the market, in the flea market, where I saw some of them selling it, and you get it for $250 for a package or $500 for a package. And they use those social security cards and green cards and also driving licenses in obtaining the employment. Now, you may ask question, what happens when the paycheck comes in? When the paycheck comes in, they take the same thing to check cashing places, and since they have all the things, the check gets cashed and that check never gets rejected, because if these people are working for some major corporation, I don't want to name the corporation, then they can get the check cashed. So this is how I have noticed that some of the undocumented aliens have been working. Now, we do appreciate the efforts of the Trump administration in weeding out the people who are not legally present in the country and who are working illegally in the country, because that's not the way that they are supposed to do. But I've seen this one. I've been requested to audit one of the fast food chain agency, Emily, and then I went and then I looked into the details, and I asked the HR, where is the green card? Here, you noted that there's a green card and there is these things. And then the HR said, according to the regulations, they're only supposed to look into the document. They don't need to keep a copy of those things. And I found out that this particular fast food agency is actually employing all illegal people. I refused to do any more audit. I gave my fees back to them. I said, I'm not going to do this one. It's up to whomever you choose want to have a lawyer. Now, I see that the Trump administration is going after those people because they know that with the same social security number, hundreds of people are working. IRS has been getting money for a long period of time, and that's how the things have been working. However, recently there are some places, workplace visits, where the Trump administration has been visiting. The ICE has definitely went in, and there are some legal people that have been detained recently, Emily. And I'm a bit concerned about for the people who are legally working in the United States, because a lot of people recently, some of the instances where people think so that, oh, I thought H-1B is the entire world. Absolutely not. A lot of these ICE agents, though, and some of these immigration judges don't understand how the adjustment of status advance parole works, how the EAD extension works. For example, if you are an H4 EAD and if the H4 get extended, you all guys know that when the EAD has been filed in the extension has been filed in the proper timing, you can work for 540-day rule. But when the ICE comes in, Immigration Customs Enforcement comes in, you don't have any document that says that you can work. What are you going to do? They may detain you at that point of time. If there is any workforce enforcement, if the ICE comes in, they may detain you. You know that in adjustment of status, where if the EAD extension is pending, you can work for a period of 540 days if the extension has been filed before the EAD expires. But the ICE may not understand. I've seen cases where the ICE does not understand these things very well. At the same time, everybody knows that if the H-1B extension has been filed, even though the approval has not been received, let's say, for example, my H-1B is expired in August 25th of 2025. My company filed an extension. I can work for a period of 240-day rule. Everybody knows that. You think everybody knows it. I know it. Our audience know it. Emily knows it. Most of the knowledgeable people know it. But these immigration customs enforcement people, they don't understand it. They don't get it. They don't look into all those books. They come with the guns and they come with the handcuffs. The first thing they will do is they arrest you, they will put you in the detention, and then they're going to look into the things detail. Now, these people are not that educated in immigration. I have to tell you that there are so many non-immigrant visas. There's called A, B, C, D, E, F, G, H, I, J, L, M, N, O, P, Q, R, S, T, U, up to you visa, there are. And in H1 category, I'll tell you one thing. There is called H1B1, there is H1B. There is also called H2 visas that are allowed to work. There is also called H3 visas that are allowed to do training at that point of time. Within the H categories, there are so many different things. So they don't understand all these rules, what you're speaking. What I would request for those people who are is that go to the I-9 regulations, print the USCIS website that you are allowed to work, whether the H-1B extension or for the EAD extensions where you are allowed to work, which where you know the and I know that you are allowed to work. Please print out those things and then keep it with you so that when the ICE comes in, then you can show it. And when I question, so at any point of time, you can show it. Emily, I am a bit concerned about some of the lawyers in Atlanta have made a statement. I don't want to name the company, but everybody knows what that company is, that there are some people who are legally working in the United States on a B visa, though. Can you explain what is this B visa is and why is these people detained when they are legally allowed to work? If you think so, they are legally allowed to work.
Yeah, there is a provision in the Foreign Affairs Manual that specifically says that in the event that obtaining an H-1B visa is going to be too time consuming or burdensome for the company, there are certain scenarios where the company can obtain a B1 in lieu of H-1B visa for that person to come into the US and do H-1B level work while they're on a B1. So when they are applying for that B1 visa, they would need to prove that they meet all of the requirements for that. So the consular officer is aware of it. They'll issue the visa stamp. Then you bring that same documentation to the port of entry. So when you enter at CBP, they are aware of the activities that you're going to do in the US and how it falls under this B1 in lieu of H1B category. And then you'll get an I-94 that puts you in B1 category, B1 status, but it doesn't provide any documentation about the B1 in lieu of H1B. So you have nothing proving that you are authorized to work in your documentation other than whatever letter you carried with you. The other issue is this works for those that qualify for the visa waiver program as well, those that use ESTA in order to enter the US, those countries that allow visitors for up to 90 days without obtaining a visa. They can use this B1 in lieu of H1 as well to come in for up to 90 days to do this specialty occupation level work if they are meeting all of the requirements. And again, they have no documentation. They don't even have a visa stamp. All they have is an I-94 that they get at the port of entry. But it is something that is allowed under the regulations. Not a lot of people are aware of it. It's not used very often, but that seems to be the situation of what people were potentially using at this work site. And, how do you prove it when ICE comes showing up at your door? Which is why, as you mentioned, I think it's really important for people that are in those weird situations where, it's easy when you have an I-797 approval notice with an I-94 on it that's not expired. You can just show that. But for people that don't have an I-797, or maybe they're in adjustment of status, so they don't have an I-797 with an I-94 on it, they just have a 485 receipt notice. They should carry the copy of that 485 receipt notice and print out the page from the USCIS website that says a pending 485 is lawful stay in the United States. Same thing as you mentioned for all of these different automatic extensions. Print out that page from the website, have your receipt notice with you, plus your expired documents. If you're on an L1 that you got it through the blanket process, again, you don't have an I-797 approval notice. You just have your visa stamp. So make sure you print out your I-94 showing that you have not overstayed. Keep your I-129S stamped with you and keep that visa stamp copy with you as well. So you have something to show those officers that may not be aware of all of the different categories and all of these different provisions that do allow you to stay lawfully in the country.
Let's go to the questions, Emily, and we want everybody to subscribe to our news channel. Please do it so that you get any updates from us. Srikanth has this question. His friend is on H1B and a 60-day grace period. Is it advisable to go on a day one CPT and continue working? Reddy Neumann Brown has been consistently telling that we do not recommend day one CPT universities. There are a couple of universities that were being dismantled, and some of the presidents and the people who manage the universities are in the jail right now. Those universities, I will name them. It's called Silicon Valley University, Tri Valley University. There are also some operations where the day one CPTs, there was a sting operation. The sting operation university was University of Northern New Jersey, and there is called Farmington University. Sting operation is where the USCIS, the immigration pretended that they were a university, they were giving a day one CPT when all the people came in, and then they arrested at least 200 people. They tried to arrest 800 people at one single time. They were able to arrest only 200 people at that point of time. Now, think of this thing though. They don't do sting operation selling Coca-Cola. The police officer will not come and tell, I'm going to sell you Coca-Cola. Will you buy it? And if you buy it, they're not going to arrest you. That's not all they're going to do it. They're going to only do it if it's a heroin or marijuana or something like that, which is completely illegal. And then when you buy it, they are going to detain you. That's how it's going to work. They're not if you buy Coca-Cola, Pepsi, they're not going to do it though. So think of this one day one CPT in the same fashion. We have had some people who got deported where they traveled outside the country and coming on day one CPTs. We do not recommend day one CPTs.
Travel Science says premium processing of an H-1B extension resulted in an RFE for biometrics. Should I go and do the biometrics? Absolutely, yes, you should. You need to do that. This is a common scenario nowadays. Not heard of anyone having any kind of difficulty giving their biometrics. ICE is not there waiting to pick you up. These are just application support centers. They're not even USCIS employees that are there. Should be a smooth process. Once you reply back to the RFE, letting them know that you've attended the biometrics, then USCIS is going to run a more thorough security check. And if there's any kind of arrest or law enforcement interaction in your past, you may receive another RFE asking for the documents of the arrest record, the court records, how the case was disposed of, in order for them to confirm whether they can issue you the extension or not. Just prepared a response for one of those today. What they're saying in these RFEs typically is just give us the documents. They don't say why. And so you have to consider whether they might look at those documents and think that they should use their discretion to deny the extension of stay. Under USCIS policy, they do have the discretion to deny an extension of stay if they think you're a bad guy nowadays, because of whatever the law enforcement interaction was. So you may want to consider, in addition to submitting the court records, also submitting all of the different positive and negative factors that show that, on balance, weighing the pros and cons, that they should exercise their discretion favorably to issue you that H-1B extension.
Question from Anil Raju. Advance parole has been issued on a marriage-based application. Is it okay to travel? Absolutely not a problem. We have not noticed any problem for the people who have an advance parole and have traveled. No problem at all. Similar question is coming from Satish. The parents, he has applied for the advance parole. They did not get the advance parole. Can they travel to India? Absolutely not. The advance parole is not approved right now. If they travel, it's going to be a big problem for the green card. The 485 will be denied. And it's going to have, and they cannot even come back on the B2 visa that they have, because now they have an intention to immigrate into the United States. So definitely not a good option for your parents to travel outside the country.
Brittany says, my EB3 is current, but I was interviewed for EB2 with a different employer. Will they automatically consider my EB3 and approve the green card, or do I have to send something in to USCIS? They do require you submit a request in writing to transfer the underlying basis from your EB2 I-140 approval to your EB3 I-140 approval. For that, you'll need to include an I-485 Supplement J from the EB3 employer, and basically make a request in writing, a very simple letter. Sometimes it takes a couple of times to get it to be processed. There's no requirement that USCIS has to do it. It's within their discretion. So if it would take them longer to adjudicate the case, they may just keep it in EB2.
Question from MSP is asking the N400 question. There are two questions on it. He has a civil lawsuit on accident issue. Will that negatively impact the citizenship application? No, I don't think so. It will have any impact on your citizenship application. VVM has this question that N400, which is used for applying for the citizenship, are there any changes? Yeah, there are some changes where they said they're going to make some inquiries, but at this point of time, though, on the form, nothing much has been changed. We recommend anybody who is eligible for the citizenship, delaying is not going to do any good for you at all. Some people say, well, I'll wait until the next administration. No, don't do that. If you're eligible for citizenship, apply right now. Because if you wait for the next administration, you still have to live with us until you get the citizenship. That's going to be a long time, because by the time next thing comes in, don't expect, what if the next one comes continuously, the same administration with a vice president becomes a president? Who knows? So at this point of time, we strongly recommend, if you are eligible for it, go ahead and apply for it. If you have some concerns, you can always discuss with the lawyer to see if it's worth applying for the citizenship. 99% of the people that I speak with, I tell them, do apply for citizenship. I don't see any reason whatsoever at all for them to delay for the citizenship application.
Anita says, how long does the 221G administrative processing take for H-1Bs or H-4s? And can we expedite it if a child is missing school? They can take as long as they want to take. They can take their sweet time. We see some that only take a couple of weeks. We see some that take a couple of months. We've seen some that take 8 months to a year. There is no rhyme or reason to it. There's no deadline for them to respond. And there's not really a way to expedite it for any reason, because they're putting all of this under national security. So if it's been more than 6 months, the best thing you could consider is a lawsuit under the Administrative Procedures Act or a writ of mandamus regarding the unreasonable delay. And you can include the fact that your child is missing school in that type of action, but otherwise just reaching out to the consulate and asking them to hurry up because their kid is missing school, I've never seen that work.
Emily, I may want your attention on this one. Mazhar Ali has applied EB3 unskilled labor, and he has been called for the interview. Is asking, is it normal? I am particularly concerned about this unskilled labor. There are been a lot of fraud in unskilled labor which has been uncovered. And I think so, if I'm not mistaken, an immigration lawyer also was been arrested, detained in Dallas on this, where the person has filed, the allegation is that the person has filed a lot of labor certifications where they charge the money from the individuals, and these people, the amount of cases they filed, none of these people ever worked for the company that filed for the green card. Even after getting the green card, it seems to be that the lawyer collected money from the employee and employer and then got them the green card, but there was never an employment, a real employment opportunity at that particular facility. This is, I'm speaking about unskilled EB3 facility. So definitely, I'm concerned for this particular guy. I definitely want you to be checked by an immigration lawyer to see everything is okay for you to go to the interview. Now, USCIS has a lot more enforcement. Is there a chance they can detain you if they find anything wrong? Yeah, they have right now given authority for the USCIS to act like an ICE agents at this point of time. So definitely you need to speak with an immigration lawyer, independent immigration lawyer, to make sure that everything is okay. What do you say, Emily, on this EB3
Yeah,
unskilled?
100% agree with that. I think they're really focused on, is there a legitimate job there? And so they're going to be asking questions about how you got the job. Who did you interview with? How did you come across the job? Was it posted somewhere? Looking into your experience to make sure that it makes sense for the type of work that you're going to be doing for this company. Has this company actually hired any of the people that it sponsored for the green card? Have they filed for a lot of people before? So there's definitely going to be a lot of questions to confirm the validity of the job and the job offer. Prem is on H-1B and asks if there's any restrictions on the number of times I can travel out of the US. I need to make at least 3 visits over the next 6 months due to a family situation. Each trip is 3 weeks long. As long as you have the visa stamp, there's no restriction on that. It is a multiple entry visa. However, each time you travel, you should carry a recently dated employer letter, employment verification letter, confirming that you are still working for the company, you're on an approved leave, and that you still have a job to come back to in the US.
Um, Question from Gayatri. She is working remotely and she's asking if that is a cause of concern when she goes for the stamping. We have noticed, especially after the COVID period, a lot of people are working remotely. There's nothing wrong with it. We haven't noticed any particularly more 221Gs just because you have a remote working. But I have to say, in general, though, that this is not the right time for you to travel to get the H-1B stamping. The questions are also coming for, is it the right time to travel? Absolutely not. We are noticing a lot more 221Gs. Just look at the messages, guys. People are posting. It's open messages people are posting. How many people are getting the rejections? How many people are getting the 221Gs? You can look into those things. We do not recommend. Now, as far as the remote job is concerned, we are fine. But in general, we do not recommend traveling for stamping at this point of time. Now, if you're not getting the point what the Trump administration is trying to do, they want to restrict the non-immigrant visas. They want to restrict the employment-based visas. That's what they're trying to do. And if you go outside the country, now that's going to be a big problem for you to come back to see if they're going to approve the visa stamping to come back into the United States.
Leah says it's been over a month since my EB1 green card interview and no update since then. Is this normal? And can we travel on AP at this time? It is normal, especially right now. They announced earlier over the weekend or earlier this week that EB1 green cards have run out for the rest of the fiscal year. That means they won't be able to approve your green card between now and September 30th. So you won't expect to hear anything. Hopefully, when things open up again on October 1st, assuming your priority date is still current, you should see some action at that time. And yes, it is still safe to travel on advanced parole at this moment.
Vikas has this question: can employer B filed an I-140 when an I-140 is pending with employer A? We don't see that a problem at all. Legally, you're allowed to do it, not a problem at all. Ganesh is having a question that his parents, along with his aunt, are coming for his housewarming party. What should the aunt say? Why is she coming into United States? But since she's coming for your housewarming party, she could simply say one thing: I'm coming to visit my nephew. That's it, simple. And she can give the details of the housewarming party if they ask more questions. Can an aunt visit a nephew in United States? Absolutely. Do they need to have their own children to come into United States? Absolutely not needed. What if they do have children and but they're coming here to for a housewarming party? They're, let's say their children are going to her children are going to college and but they're coming for your housewarming party. The aunt can still say that she's coming for nephew's housewarming party. Not a problem at all.
Mr. Z says, I'm on H-1B. Current I-797 expires June 2026, maxing out July 2027. Perm filed January 2025. Do I have enough time being from rest of the world? Should the H-1B extension be filed in premium processing? Well, you don't necessarily need enough time being rest of world because you are eligible for a 7th year extension of your H-1B because your perm was filed before your max 1 year before your max out date of July 2027. So since your perm will be pending for 365 days in January and you're eligible to file your H-1 extension in January, you can request an H-1 extension from June 2026 through July 2027, plus an extra year to July 2028 based on your pending perm. You could do that in regular processing if you file it right in January. If you're going to wait a little bit, file it in premium processing. That should give you till July 2028. By then, you should have an approved I-140. If your priority date still isn't current in rest of world, you can file another extension of your H-1B and get a 3-year extension based on your approved I-140.
So Denu Agarwal has this question that he is an H-1B, he has an advanced parole, he has a travel plan to go to India. Should he get the H-1B sample or should he just come back on advanced parole? By coming back in advanced parole, would he be considered to be moving to EAD? I strongly recommend that you do not go for H-1B stamping. You can come back in advance parole. Your H-1B is still valid. You can still work on H-1B. You can extend the H-1B. You can amend the H-1B. You can transfer the H-1B. Now, whether or not you need a H-1B is a different question, but the H-1B does not become invalid by you traveling in advance parole. What I strongly tell is that do not go for stamping. That's not advisable for you. It's unnecessary. You're blocking the time of somebody else. You do not need it.
Nagaraj says, are H-1B transfers getting approved smoothly? Yes, a lot of them are. I still see a lot of transfers getting approved in premium processing. Regular processing is taking a little bit longer. Some of the new wrinkles that come up with H-1B transfers, number one, are these biometrics appointment notices. So they are sending a notice saying we're going to send you for biometrics, respond to the RFE once you attend. And then once they run that security check, if there's any kind of arrest history, they will send another RFE asking for all of the court documents. And then they will decide whether to issue the approval of the extension along with the transfer or not. The other kind of new wrinkle that's happening sometimes with H-1B transfers is the signature issue. USCIS expects that when you are signing a petition as the employer is supposed to be signing in a wet handwritten signature, and then they can scan a copy of it to provide it to the attorney to be mailed off. So you can submit a scanned copy of a wet signature. It has to be handwritten. Some companies have been using an electronically copied version of the same signature over and over again. And now they're getting notice of intent to deny because they're saying this is not a wet signature copy. We want to see the originals because you're supposed to keep the originals on file. So that is something that might be dealt with through litigation. But those are really the main things I've been seeing with transfers, other than sometimes we also see that they are checking into your prior employer to confirm that you've actually maintained your status properly with that company, that you've received the correct amount of pay, looking at your pay statements. They look at your pay statements to verify that your address matches the LCA of your old employer where you're supposed to be working. So sometimes those can cause a problem for transfers nowadays.
Abhijit Sen has this question. He's a green card holder. He has some property issues in India that he wants to take care. He thinks so it's going to take 3 to 4 months, less than 6 months. Can he travel and will it cause any problem? Now, if it's less than 6 months, I don't see any problem in you traveling outside the country. But here is Mr. Abhijit Sen that I want you to be very careful. Listen to me. I'm a lawyer in India. I know how the property deals goes on. It doesn't end sometimes in 3 to 4 months. If it is extending beyond that period of time, where you're coming very near to the 6 months period, though, at when you touch the 5 months period, that's when when you cross the 5 months period, 5 months and 1 day, I want you to do one favor to me. I want you to fly to United States, at least spend 1 day and go back to India. That's my advice to you. Now, if you don't want to follow that direction, you want to spend more than 6 months, you can have a consultation with me. I charge a good amount of money for consultation. And I will tell you some of the plan, but it's not worth paying Raul Reddy $400 for consultation. It's not worth. Believe me on that. It's probably worth for you to spend money in traveling to United States and going back within the 6 months period rather than having a consultation with a lawyer and spend more than 6 months outside the country. It's not worth consulting a lawyer. Please try to cut down and come back within 6 months.
Hassan says he has his I-140 approved on September 5th, just recently, and wants to know if the new employer files an H-1B transfer before 180 days, but the job starts after 180 days. Is there any negative consequence? Has nothing to do with the transfer at all. The issue is your current employer, who you have the I-140 approved with, going to withdraw your approved I-140 if you leave within the next 180 days? If the answer is yes, then you should wait until after 180 days to take any action that's going to cause them to withdraw it. If they don't withdraw the I-140, then it doesn't really matter at all when you file a transfer or not.
Um, People are asking question, is the Dropbox still available for visiting visa? The answer is there is no more Dropbox anymore, guys. You will have to not use, get used to it. There's no Dropbox. Ashwant has this question. I'm an H4 EAD. Can I file a permit I-140? Yes, you can. You don't have to be an H-1B to file for an I-140. A lot of people are confused that, especially we see people, couple are there, wife and husband are there. One of the person moves on to H-4 EAD because they maxed out on the H-1B. They use the spouse's I-140 approval to move on to H-4 EAD. Get an I-140 approval. The reason is that who knows? Your spouse might lose the job. You may need to be an H-1B later on. And you can do it if you have the I-140 approval. You can file an I-140 on H-4 EAD. Absolutely not a problem.
Satish from X says, if you have have a valid AOS EAD, do you still need to carry the 485 receipt notice, or is the valid EAD copy okay? Um, I would say carry the receipt notice too. It might be overkill, but if it keeps you from being detained in the event of a worksite raid, it's worth it, because an EAD doesn't prove you're in status. It just proves that you're authorized to work. So the 485 receipt notice is what confirms that you are lawfully present. You could go one step further and print out the page from the USCIS website that says pending adjustment of status is lawful presence.
Question, I am a permanent resident in Canada. Can I get the H-1B stamping in Canada? Yeah, if you maintain the permanent residency in Canada, yeah, technically you are eligible for the stamping in Canada. This is only because you are a permanent resident and you're maintaining a residency in Canada, then you probably will be eligible in getting the stamping in Canada.
Bimshi says, is EB5 preferable now? And are there any issues around that? Well, it's preferable if you are born in India and don't want to wait for your green card in the EB2 or EB3 category. EB5 is the only category that is current for country of birth India, and that's not going to last much longer. So if you particularly have an issue with maybe kids about to age out, or you're just sick of waiting, then yeah, EB5 is preferable for that reason.
Um, Question from Pranav. What about the cases where there are emergency and then you have to travel to India, though? Definitely, you have to evaluate whether it's worth for you or not, because most probably your chapter in United States will be closed, at least for the foreseeable future, though. The reason is that if you don't have an appointment already there, let's say assuming that you are on H-1B or L-1 visa and you're going outside the country, your stamping has already expired, then you go, and you may not get an appointment for the next 6 months to 1 year. And a lot of jobs won't be there waiting for you if you leave the country. So then practically you will not be eligible for H-1B. So you have to evaluate how emergency it is. I'm telling you that I'm a parent of a child. I don't want my son's future to be destroyed if something happens to me. And if my son's future is destroyed because something happened to me, I won't live in peace after I die. That's me as a dad. I can think about it. Now it's up to how each parent can think. That's up to them. But that's how I think that my son's future should not be destroyed because of me. And I think so. Most of the parents think the same way too.
Vikas says USCIS has been issuing these RFEs regarding the wet signature on the I-129 application. What do you do if the I-94 is already expired for your H-1B extension and you got one of these RFEs? In case of a denial, can a new petition be filed under Nunc Pro Tunc? And yes, it can. You definitely would want to file that in premium processing because you need to watch the 180-day unlawful presence clock. Um, Once that extension has been denied and your I-94 is expired at that point, USCIS does have authority to issue an NTA and put you in removal proceedings. Have not seen it happen yet, but that is a possibility. So you need to weigh that risk. And then also keep in mind that once that 180-day clock starts from the date of the denial, if you don't have a result on your nunc pro tunc filing yet, you may need to leave the country to avoid hitting 180 days of unlawful presence and triggering a 3-year bar. So there's definite risks with all of the different options there, and you'll need to think really thoroughly to decide which one's going to be the best route to go.
How long the LCA approvals are taking nowadays for the H-1B? We have noticed LCA, labor condition applications. They are getting approved within like about, I would say, between 7 days. That's the normal time that we're looking into LCA approvals nowadays.
Mohan says, is this new that H-1B extensions are being required to disclose past misdemeanors or convictions? Is USCIS doing their own background check? Was this the case in past years? So it's new. In the prior years, I can say maybe 5 times I have seen an I-129 where they maybe had a DWI or something like that, and it was raised in an RFE. So it's definitely new that they are running these security checks and then calling for biometrics and then asking for all of the documents based on that.
Questions are coming with regards to, I already have a stamping in February 2026. working with EVV, that means employer, vendor, main vendor, and client. If I visit, is that going to be a problem? If you already have a stamping until February 2026 and you have a job, we do not see that as a problem for you to travel outside the country. We particularly recommend people to avoid two airports. One is Abu Dhabi Airport and definitely Chicago Airport. These are the two airports we recommend to avoid.
Um, Sri says my friend's L1B expires in May 2026 and he's filing for the extension. Should he go for normal or premium processing? His company's lawyers are suggesting to travel to India for the extension. He's married and has a 2-year-old child. I'm assuming this is under a blanket, which means he does have the option of going to India for the renewal. But generally, under the Trump administration, because travel is risky, visa stamping is risky, unless there's a specific reason to go for visa stamping, I am filing my blanket renewals or recommending to my companies to file their blanket renewals with USCIS and in premium processing. I do have some people that have to travel frequently to where it would be inconvenient for them to stay in the US and wait for that extension to be processed. And then they have to travel. So they're going to have to go for stamping anyways. So that kind of makes sense. But if you don't have to travel, I'm filing with USCIS.
Question from X, it's number 44 is saying, I-140, they didn't retain the priority date of the previous employer's I-140 approval. Is it a USCIS error? Definitely it's a USCIS error. We do not see, I mean, if you have provided the previous I-140 approval and they did not update it with the priority date, you can contact the USCIS to correct it. You can refile the I-140 to get the previous I-140 date, but it definitely is an error though. They have to do it. They have to give you the previous I-140 priority date.
Gayatri asks, after undergoing a change of status to H-1B in the US, if in the future during the consular interview it's refused, will the H-1B lottery cap be revoked? Potentially. So just having the visa denied at the consulate doesn't automatically mean that the petition is going to be revoked and that you lose your cap. But if the um, consular officer feels that there was any kind of fraud or misrepresentation made in that petition, they can then send the petition back to USCIS, instructing them that it should be revoked. USCIS then has to inform the company that they intend to revoke. They'll send a notice of intent to revoke. And if it alleges fraud or misrepresentation, and then the company responds and a finding of fraud is there, then the cap number is lost due to that revocation.
Um, Shravan has this question. Trump is making all these things under emergency provisions. Is there a possibility that the court can reverse it, though? Particularly when it comes to the visa issuance and whether the third country nationals can be issued, though, I don't think so. The courts are going to interfere into that, though. Definitely, they are not going to interfere. That's my reading of the law.
Cheyenne says if you already booked your appointment after September 6th in a third country, does USCIS honor those appointments? So if you already had your appointment booked before the announcement, but the appointment is not scheduled until after September 6th, you can still attend the appointment that you already have. But if after September 6th, you go and book an appointment in another country, they will turn you away and you don't get your money back from that visa application.
Raja Turun has this question. He has used 6 months of H-1B in 2018, left the country. It shows it's been revoked because of the withdrawal. Does it? He's asking first, is a withdrawal shows as revocation? Yes. When the company withdraws it, they call it as automatic revocation. That's not a problem. That's since you have used up 6 months of the H-1B, though. If the H-1B is revoked because the company has withdrawn, and which normally when the company withdraws, they show it's been revoked, automatic revoked, you can still use the rest of the 5.5 years to come back into the country. You don't need to go through the lottery. However, when you come on H-1B, you can't use the full 6 years, but you can use the 5.5 years. Even though it's been withdrawn in the 2000, your 2018 petition, you can still come back. You don't need to go through the H-1B lottery. This is for Raja Tarun from X. Raghu is asking the question, can I travel on advance parole? I have an EAD approval for 85 waiting, priority date is August 2014. Absolutely. If you have an advance parole, I have not seen any problem for the people who have an advance parole to travel. They are allowed to travel. I've never seen any problem with advance parole having problem.
Srijani says, my parents left the US in May 2025 after staying close to 6 months on B2. Can they travel again before Christmas and stay for another 5 months? Will that be a problem? It's not automatically a problem. Um, However, when they're coming in again, they need to be ready to convince the officer at the airport, at the port of entry, that the purpose of their entry in the US is to visit, that they have a set time, a temporary period that they plan to stay in the US, that they have a home abroad to return to at the end of their stay, that they have sufficient funds to take care of themselves while they're in the US. And the officer has to find all of that to be credible in order to let them in again. Um, so just the fact that they've already been to the US previously for a longer period of time by itself is not a problem if they're able to convince the officer on this trip that again they will comply.
Anup has this question. His wife filed a EB2 NIW application, but wife's H1B, wife end date of job, or H1B expiration is September 30th. Will it affect the NIW? No, it does not affect the NIW. You can do one thing. I mean, you can do premium processing if you want to. That's option is there. Just because your wife ended H1B will not going to automatically affect NIW. Assuming that she's going to move to a different visa status after September 30th, she can continue with the NIW application, though. Not a problem.
Raj Tharoon from X says, does a withdrawn H-1B also show up as revoked in the portal? Yes, it does. When USCIS receives a request to withdraw an H-1B because employment has terminated, they issue a revocation of that H-1B. That's what's been causing some of these NTAs over time, because they're not looking properly into whether the person has continued to maintain their status after that revocation. But yes, it does show up as a revocation, not a withdrawal.
That's the concern, Emily. Emily, I have concern about these people having to go to the employers and reviewing all these employees when the USCIS cannot determine the person is in legal status or not. How is this ICE people who are not well educated as much as the USCIS is? I'm a bit concerned about what happened in Georgia, though, where they
Yeah.
said, okay, we arrested 400 and so people. I have had the situation in 2000 where 40 Indians were been arrested at one point of time, and all of them happens to be my clients. And everybody, all the 40 people of my clients were in legal status. Now, there are a lot of people that were working in San Antonio Air Base at that point of time, but 40 people were being arrested at that point of time. And everybody was in legal status, Emily. And we were able to prove they dropped the case, but it was a nightmare for them to put them in the detention centers for a while. And then we got the bail, and then we have to go and explain and got those things resolved. What's the solution for this?
Yeah, with ICE, I feel like they are detain first, ask questions later. It's very difficult when you're in that situation. And at the same time, you also have the right to remain silent in the event of a work site raid so that you don't accidentally say something that, they're going to misinterpret as you not having proper status. So you really need to just be prepared for what you would do in that situation. Again, have those documents available, but know that even if you have the documents available, ICE just is going to detain anyways and figure it out later. Seems to be their plan.
I had one lady who has been transferred from H4 to H1. Emily, H1 was been approved. I had the H1 approval with the I-94. She wrote a document to the ICE that she is working illegally on
Oh,
illegal in United States when the ICE raid happened. She's panicked. She doesn't
Mhm.
know what she's speaking.
Yeah.
She's panicked. She signed the document.
Yeah,
Definitely, I
don't
would
sign any document.
without consulting a lawyer. And we want you to guys that if you don't have the proper, when I say proper documentation, for example, if you have the H-1B approval with company B, I don't have any problem. If you have the H-1B extension, you have the document, they will be able to understand. But if the extension is filed and you don't have the extension approval, they are going to go mad. They don't understand what this is. So definitely, I want you to print out the USCIS thing and show it to the officer. Hey, look, I am in legal status according to USCIS. I have the H-1B approval with company A. I have the H-1B extension receipt notice based on the USCIS website. I can work for 240 days. Keep it with you. That will help you out.
This question says, can you travel to India in October if you have a valid visa stamp till November 2025 and the passport is valid until February 2026? Assuming that you have status till at least November 2025, preferably beyond that, then yes, you can. Just the fact that your stamping is expiring a month after you're entering is not a problem. It just needs to be valid on the day that you are entering. If your I-797 is valid beyond your passport validity of February 2026, make sure to check your I-94 to make sure that they gave you the I-797 end date, not your passport end date. I've even seen recently where they gave the visa end date instead, which would really cut your stay short if that's the case. So always check that as soon as you enter. Go to deferred inspection if they get it wrong.
My CV canceled 9 months back, and I now enroll in a new college and reinstate my service. Do I need to go to India and attend the visa stamping? Yeah, if you go to it's I think so chapter for you most probably will be closed in the United States because it's been more than 5 months that your service has been canceled. If you go to India, they're not going to give you the stamping though. You may want to look into alternative options, what you can do, but definitely going to India, they are not going to give you the stamping. And that looks to be the only option for you at least, and but that most probably will not be given to you.
Vivek says, I filed for H-1B, still waiting for the approval. And with checking with other people, everyone's saying it's taking longer nowadays. What is the reason? The Trump administration, they do not like legal immigrants. They're not going to do any favors to you. If they can make things take longer so that you give up or, it messes up your job or your status, they will. We've seen that before. So premium processing, again, is the way to go.
Anything else, Emily, before we close?
Oh, I guess we are out of time for today. Thanks everyone for joining. We'll be back again next week. Definitely subscribe to our channel so that you get the updates, especially when there's any breaking news. We do other immigration topics that tend to come up during the Trump administration.